Imagine you walk into a bank, right?
Sure.
You want to secure your life savings.
Okay.
And the manager says to you, well, before we give you a vault, you have to hand over the exact combination, the blueprints to your security system at home, and a detailed list of literally every asset you own.
Right. Total transparency.
Exactly. So you hand it all over, and then the manager looks at your application, stamps rejected across it in red ink, and instead of giving your combination back, they print it on a giant billboard out in the lobby for the richest people in town to read.
And you walk away with nothing.
Nothing. No vault, no protection. And everyone knows exactly how to access your assets. That is the United States patent system for a startup founder.
Yeah.
So welcome to today's deep dive. We are bypassing that whole romanticized myth of the lone inventor in a garage today.
Yeah, that myth is completely obsolete.
It really is. Today, we're looking at the cold, hard mechanics of intellectual property, specifically for you, the global innovator, the startup founder, the engineer, trying to navigate a system that you probably think was built to protect you.
Well, the framework you're operating under, it's a highly engineered trap.
A trap.
Precisely. To understand the modern patent landscape, you really have to abandon this notion of a patent as some sort of certificate of genius or, a moral reward for innovation. It's not.
It's just business.
It is strictly a financial instrument. It's a mechanism of leverage. And the defining metric of that instrument is the cost of engagement. Right now, a United States patent litigation defense costs, on average, $4 million.
Wow.
That single figure dictates literally every rational move on the board.
Okay, wait, let's unpack this. $4 million just to defend yourself. We aren't talking about paying damages if you lose or settling out of court.
No. That is just the sheer capital required to stand in a courtroom and say, I didn't steal this, or my patent is actually valid.
That is insane. How does the meter even run up to $4 million?
Well, it's a war of attrition waged entirely through procedure. When a well-capitalized entity sues you, they don't just file a piece of paper. They initiate a multi-year extraction process. First comes discovery.
Right.
They will demand terabytes of your internal communications, your source code, every engineering note your team ever made.
You have to pay someone to read all of that.
Exactly. You have to hire specialized law firms charging $1,000 an hour just to review your own documents for privilege.
Unbelievable.
And then come the depositions, right? Pulling your lead engineers away from product development for weeks at a time. Then you have the Markman hearings.
What are those?
That's where millions are spent battling over the legal definition of single words in the patent claims, words like calculating or, adjacent.
Arguing over vocabulary.
Yeah, purely to drain your resources. And finally, you have the parade of expert witnesses. They easily command tens of thousands of dollars a day to testify. So the $4 million figure, it isn't a bug in the justice system. It is a meticulously constructed filter.
A filter to weed out anyone who isn't a billionaire. It just creates this completely asymmetric battlefield. If you're a startup, right, you've got maybe $5 million in total funding, and a conglomerate hits you with an infringement suit, your technology is completely irrelevant.
It absolutely does not matter how good your tech is.
Right. Your slingshot is just tied up in appellate court, and your entire runway vanishes into legal fees before you even get to argue the actual merits of your invention.
And if we connect this to the bigger picture, that capital requirement leaves only two mathematically viable strategies for navigating intellectual property today. I categorize them as the SAND strategy and the STARS strategy.
SAND and STARS. Okay, let's start with SAND.
The SAND strategy is the only logical posture for an undercapitalized innovator. Discretion is your singular defense. You have to rely entirely on trade secrets.
So just don't tell anyone anything.
Precisely. Trade secrets act like sand. They are hidden, granular, constantly shifting, and essentially impossible for an opponent to map or target. You do not file with the patent office. You don't publish white papers.
You just stay off the radar entirely.
You compartmentalize your engineering teams, enforce ironclad non-disclosure agreements, and keep the actual mechanics of your innovation completely dark.
Because, the moment you publish, you're visible. You become a fixed target on the map.
You do, which brings us to the STAR strategy. This is the exclusive domain of the conglomerate.
Right, the guys with the $4 million to burn.
For massive corporate entities, power is not derived from secrecy. Power is density. A single patent is a vulnerability. It can be challenged and validated or, invented around.
Sure.
But 100 overlapping interconnected patents, that forms a constellation. This is what we call the statistical moat.
A statistical moat. So they're just burying you in paperwork.
Conglomerates flood the zone with so much overlapping intellectual property that it makes litigation mathematically irrational for any opponent. You aren't protecting a single brilliant, groundbreaking idea. You are building a $4 million toll booth on every possible micro-iteration of a standard concept.
So what does this all mean for you listening right now? It means we are not celebrating human ingenuity today. Not at all. We are analyzing raw leverage.
Yes.
We're going to examine 3 pivotal Supreme Court cases. Gottschalk v. Benson, Diamond v. Diehr, and Burnett Machine Works v. Cockham Industries to reveal a very, very bleak reality. The patent system is not a shield.
It is not.
It is a treasure map handed directly to your competitors. So to understand how the independent developer gets systematically strip-mined of their work, we have to start with the fundamental danger of engaging with the system in the first place.
The disclosure trap.
Yeah.
To observe the disclosure trap in its purest form, we have to analyze the 1972 Supreme Court case, Gottschalk v. Benson. The strategic takeaway from this case is, well, it's devastating for anyone writing code or developing algorithms today.
Devastating is the right word. Let's look at the mechanics of what actually happened here. Since the early 1970s, computing is finally moving from those massive room-sized mainframes into more, versatile applications.
Right.
And Gary Benson and Arthur Tabbitt, they develop a highly valuable method for converting numerical information. Specifically, they figure out a way to convert binary-coded decimal numbers, where each decimal digit is represented by a sequence of binary bits, into pure binary numbers on a general-purpose digital computer.
And this wasn't just some academic exercise.
No. Finding a highly efficient, fast way for a machine to process these fundamental conversions, that was a massive bottleneck in computer science at the time. They solved it, and so naturally they applied for a patent.
Because under the Patent Act of 1952, specifically Section 101, an inventor can obtain a patent for any new and useful process, machine, manufacture, or composition of matter.
Right, and they thought this was a new process.
Benson and Tabbitt submitted their conversion method as a new and useful process, but the patent examiner rejected it. Then the Board of Appeals upheld that rejection. The appellate court reversed it, and finally, the Supreme Court took the case to settle the boundary line of what actually constitutes a patentable process.
And the Supreme Court ultimately sided with the Patent Office. They killed the patent, and the weapon they used to kill it was the preemption argument.
Yes. The preemption doctrine is a judicial creation. It's rooted in 19th century precedent, dictating that you simply cannot patent a law of nature, a physical phenomenon, or an abstract idea.
Because then you'd own nature.
Exactly. The court, led by Justice William O. Douglas, reasoned that Benson's algorithm was simply a series of mathematical calculations, mental steps. The court stated that granting a patent on this algorithm would wholly preempt the mathematical formula itself.
Meaning, Benson and Tabbitt would essentially own the math.
In practical effect, yes. The court noted that the claim was not limited to any particular piece of machinery or any specific end use. If you granted that patent, no one else could use this mathematical method for any future invention.
In any field.
Right, in any field, on any computer, without paying a toll to Benson. The algorithm would be entirely monopolized. Therefore, the court ruled it unpatentable subject matter.
And, on the surface, if you're just a casual observer, that sounds perfectly reasonable. We don't want someone copywriting the law of gravity or, patenting the concept of addition and charging us every time we calculate a chip at a restaurant.
Strategically, it makes sense for the public domain.
Right. But here's where it gets really interesting and incredibly dark for you, the innovator. Because the true tragedy of Gottschalk v. Benson isn't that they were denied a monopoly. The tragedy is what the application process extracted from them. They fell headfirst into the disclosure trap.
This requires a very cold analysis of the statutory bargain at the heart of patent law. Section 112 of the Patent Act demands complete transparency.
A bank vault lobby.
Exactly. To even apply for a patent, you must provide a written description of your invention in such full, clear, concise, and exact terms that anyone skilled in the art could replicate it.
You have to give them the recipe.
You must also disclose the best mode of carrying out your invention. The theoretical bargain is that you enrich the public domain with your knowledge, and in exchange, the state grants you a 20-year monopoly to commercialize it.
But the state didn't give Benson the monopoly. They took the knowledge, published it, and gave him absolutely nothing in return.
They lost their case, and simultaneously, they lost their trade secret.
It's sickening.
By fully mapping out their algorithmic process to satisfy Section 112, Benson and Tabbitt documented exactly how to solve a critical computing bottleneck. When the Supreme Court ruled the algorithm was an unpatentable, abstract idea, that documentation didn't just disappear.
No, it became public record.
The blueprint was handed over to every major technology conglomerate of the era, completely free of charge.
It's literal state-sponsored extraction of intellectual property. I mean, think about the timeline here. You file your application. The patent office or the courts during an appeal, they make that information public. Massive tech conglomerates actually have automated systems and teams of lawyers whose sole job is to monitor patent office databases.
They are constantly watching for these rejections.
Right. They're waiting for a brilliant startup to try and patent a pure software process, get hit with a Section 101 abstract idea rejection, and then the conglomerate just swoops in and commercializes the now unprotected trade secret.
What is fascinating here is how this violently alters the risk-reward calculus for a software developer today. Taking a pure algorithm to the United States Patent Office is a catastrophic strategic vulnerability.
It really is.
You are walking into a casino where the house rules on what constitutes an abstract idea are notoriously chaotic and constantly shifting. If you fall on the wrong side of that nebulous boundary, you don't just lose your legal fees, you lose the core asset of your company.
You lose everything.
The system demands total, unilateral vulnerability from the innovator upfront, while reserving the right to deny the protection years later.
It's a legal harvesting machine. The underfunded do the heavy lifting of true innovation. They naively ask the government for protection, and the government essentially strips them of their armor and feeds them to the giants. And there's no undo button. You cannot unpublish a concept once it's in the public domain.
You cannot. And this realization forces us to examine the evolution of the board. If Benson demonstrated that pure, unprotected math is a trap, the conglomerates had to find a way to secure monopolies on algorithms without triggering the preemption doctrine.
Because they still wanted to own the software.
Of course. And they found their loophole in 1981, and it became the foundational blueprint for the STAR strategy.
Okay, so we're moving from pure software in a vacuum to heavy industrial application. The case is Diamond v. Diehr. And this is where the cold mechanics of the system really start to favor the heavily capitalized players.
In 1975, inventors Diehr and Lutton filed a patent application for a process of molding raw, uncured synthetic rubber into precision-cured products.
Tires and stuff.
Yes, but to understand the leverage here, we have to dissect the exact claims of their patent, because the devil is entirely in the mechanical details.
Yeah, and curing synthetic rubber is a notoriously difficult thermodynamic process. You're dealing with heat transfer inside a closed, pressurized mold. If you open the press too early, the rubber is undercured. It's gooey and useless.
Right.
If you open it too late, it's overcured and degrades, it's brittle. The industry had been struggling for years to pinpoint the exact moment to open the press because you simply couldn't get a perfect real-time temperature reading inside the sealed mold.
So Diehr and Lutton proposed a method that operated the rubber molding press with the aid of a digital computer. They provided the computer with a database that included the activation energy constant for the specific batch of rubber being used.
Okay.
When the press closed, an interval timer initiated. A thermocouple continuously measured the temperature inside the mold and fed that data to the computer.
And here is the critical part, right here. The computer took that temperature data and repetitively calculated the Arrhenius equation.
Yes. And the Arrhenius equation is a deeply established law of physical chemistry. It's not new. The natural logarithm of the reaction rate equals a constant times the temperature plus another constant.
It had been around forever.
The digital computer continuously compared the elapsed time with the required cure time calculated by that equation. The moment the numbers matched, the computer sent a signal to automatically open the press.
Wait a minute, wait. 9 years earlier, in Benson, the Supreme Court unequivocally stated that you cannot patent a mathematical algorithm because it preempts the math. But Diehr and Lutton are literally using a digital computer to run a standard, centuries-old math equation. How is this not the exact same trap?
Because of the physical wrapper.
Through wrapper.
Yes. In a 5-4 decision, the Supreme Court allowed the patent. The strategic loophole was officially validated.
Unbelievable.
The court's majority argued that Diehr was not seeking to preempt the Arrhenius equation. They were not claiming ownership over the math itself. Instead, they were using the math to transform an article, raw synthetic rubber, into a different state or thing, cured rubber.
So it's just about the rubber.
The court ruled that an otherwise unpatentable algorithm could become patent eligible if it was integrated into a larger process that physically transformed matter.
Okay, I am going to channel the absolute cynicism of Justice John Paul Stevens right now, who wrote the dissent in this case, joined by Justice Thurgood Marshall. If you strip away the legal gymnastics and look at the actual engineering here, this ruling is a complete farce.
From a purely technical standpoint, yes.
The patent taught the industry absolutely nothing new about the chemistry of synthetic rubber. It introduced no new raw materials. It invented no new hardware. The thermocouple was just a standard piece of equipment. The rubber press was totally conventional. And the Arrhenius equation had been in textbooks for decades.
The process was entirely composed of conventional industry practice, save for the presence of the digital computer calculating the formula.
Exactly. All Diehr and Lutton did was take a well-known mathematical formula, staple it to conventional industry hardware, and suddenly the Supreme Court hands them a monopoly. The physical transformation of the rubber wasn't the innovation.
It was an anchor.
It was a Trojan horse. It was a camouflage wrapper used to sneak the algorithm past the patent examiner's desk.
And this raises an important question regarding strategic deployment. Because for a coal strategist, advising a Fortune 500 company, whether the innovation is a genuine breakthrough or just an illusion wrapped in conventional hardware is completely irrelevant.
They don't care about the science.
The validity of the underlying science doesn't matter. The precedent matters. Diehr taught corporate conglomerates that you do not need pure, high-risk innovation to secure a monopoly. You just need to tie your software to a tangible machine.
Just staple the code to a toaster or a rubber press or an engine block, and you get a patent.
Precisely. By weaponizing this exact loophole thousands of times over, massive corporations build their statistical moats. If I am the general counsel for an industrial conglomerate, I'm not going to fund high-risk research to invent an entirely new manufacturing paradigm. That is an inefficient capital allocation.
Why bother?
Exactly. Instead, I'm going to have my engineers write optimization software for every single existing machine in our supply chain. I am going to file a patent for every single one of those hardware-software combinations, citing Diamond v. Diehr.
And this is where the $4 million math becomes a weapon of mass destruction against the independent innovator. If you are a startup trying to build a better factory automation system, you aren't fighting one great innovative patent. You are facing a wall of 1,000 overlapping, highly specific patents that are basically just math stapled to a machine.
And if a conglomerate holds 2,000 patents on slightly different variations of computer-timed industrial equipment, it fundamentally does not matter if 80% of them are technically invalid, overly broad, or merely stapled formulas that never should have been granted.
Because of the toll booth.
Right. You, the undercapitalized competitor, cannot afford to prove that they are invalid. To challenge the validity of even a single patent in an interparts review or federal court costs millions. To challenge a portfolio of 2,000 is a financial impossibility.
The conglomerate isn't relying on the legal purity of their claims. They know half their patents might be junk. They are relying on the sheer gravitational pull of their legal budget. They flood the zone with the STARS strategy, building a dense constellation of IP. It shifts the entire purpose of the patent system. It is no longer about protecting the lone genius. It is just a brutal validation of capital superiority.
The moat is impassable unless you also have billions in cross-licensing leverage, and the malleability of the system extends far beyond just tying algorithms to machines. The rules of what can be owned are entirely negotiable if you have the resources to push the boundaries up the appellate chain.
If you could just keep appealing until you get the judge you want.
To observe the ultimate expression of how capital dictates precedent, we really must examine Diamond v. Chakrabarty.
Oh man, this case. This case fundamentally altered the landscape of biology. We are moving from the mechanical manipulation of rubber to the genetic manipulation of life itself.
Yes, the stakes change dramatically here.
So, the year is 1980. We have Ananda M. Chakrabarty, a genetic engineer working not in a lone garage, but for the corporate behemoth General Electric. He develops a bacterium derived from the Pseudomonas genus, specifically Pseudomonas putida,
Right.
he engineers it using multiple plasmids to be capable of breaking down crude oil. It is a human-made, genetically modified microorganism designed for environmental cleanup.
And General Electric immediately filed a patent application listing Chakrabarty as the inventor. But the patent examiner, strictly adhering to the historical understanding of 35 U.S.C. Section 101, rejected the patent claims for the bacteria itself.
Natural.
For centuries, the foundational rule of patent law was that you simply cannot patent nature. You can patent a mechanical device, you can patent a chemical process, but living things were explicitly outside the statutory framework.
Because life isn't a manufacture. You can't mass produce a monopoly on a living organism that replicates itself. It's absurd.
Well, General Electric refused to accept the rejection. They appealed to the Board of Patent Appeals and Interferences. They lost.
Right.
But then they escalated the fight. Leveraging their massive capital reserves, they appealed to the Court of Customs and Patent Appeals, where they won a reversal. Then the Patent Office, under Commissioner Sidney Diamond, escalated it to the Supreme Court.
And here we go.
And in a narrow 5-4 decision authored by Chief Justice Warren Burger, the court ruled in favor of General Electric.
The Supreme Court looked at a living, replicating organism and ruled that it was a patentable manufacture or composition of matter.
The majority opinion relied on a deeply expansive interpretation of the 1952 Patent Act. Chief Justice Burger reasoned that Congress intended patentable subject matter to include anything under the sun that is made by man.
That is so broad.
It is. While the court acknowledged the precedent that you cannot patent a new mineral found in the earth or a newly discovered wild plant as those are mere manifestations of nature, they argued that Chakrabarty's bacterium did not naturally occur. Because it was the product of human genetic engineering, the fact that it was biologically alive was deemed legally irrelevant.
Here is where the cynicism of anyone analyzing this system should absolutely redline. The hypocrisy between the ruling in Gottschalk v. Benson and Diamond v. Chakrabarty is just staggering. Justice William Brennan, joined by Justice Thurgood Marshall, wrote a blistering dissent that exposed the massive contradiction in the majority's logic.
The contradiction centers entirely on statutory interpretation and congressional intent.
Yes. Think about it. In Benson, the court blocked the independent software developers from patenting their algorithm. The logic there was essentially, hey, Congress hasn't specifically updated the 1952 Patent Act to explicitly authorize the patenting of computer software, so we, the court, are going to maintain a strict narrow reading and deny the patent. We will not expand the law without Congress telling us to.
A very conservative textual approach.
Exactly. But in Chakrabarty, Congress had spoken on the issue of patenting life. They literally passed laws about it.
Yes. The dissent heavily cited the Plant Patent Act of 1930 and the Plant Variety Protection Act of 1970.
Exactly. Congress had specifically, deliberately legislated on the boundaries of patenting living organisms. When they passed those acts to allow narrow protections for very specific types of agricultural plants, they explicitly debated and then excluded bacteria from patent protection.
They drew a clear line.
They looked at bacteria and said no. Justice Brennan's dissent was furious. He pointed out that Congress demonstrated a clear, undeniable intent to exclude living microorganisms from general patent laws. He argued that granting General Electric a monopoly on a life form was an egregious overreach, a massive expansion of corporate power that directly defied the legislative branch.
Look, if we evaluate this analytically, stripping away any optimism or, belief in judicial consistency, we are left with a stark reality. The legal framework is entirely malleable when sufficient capital is applied.
Completely.
And we're not evaluating whether judicial activism in 1980 leaned left or right. I want to make that clear. Political ideology is irrelevant to the cold strategist. We aren't taking a side on the politics of the Burger Court.
Right. This isn't a left-wing or right-wing issue. It's a money issue.
Exactly. What matters is the deployment of resources. General Electric possessed the capital necessary to wage a multi-year, multi-tiered appellate war. They fought from the examiner's desk all the way to the highest court in the land to literally redefine the legal definition of life to fit their corporate portfolio.
Meanwhile, Benson and Tabak get stripped of their trade secret and sent home with nothing. It is a breathtaking double standard. The Supreme Court rigorously, brutally applies a strict reading of the rules to block the pure algorithmic innovation of the individual. But when a massive industrial conglomerate wants to patent the living organism, the court suddenly discovers an expansive, flexible interpretation that overrides clear congressional intent.
The law is not a static set of guardrails, it is a dynamic resource. And like any resource, access is restricted by price. A small innovator operating under the sand strategy, trying to keep their head above water, simply cannot afford the millions of dollars required to fight a patent examiner, then brief the Board of Appeals, then argue before the Federal Appellate Circuit, and then petition the Supreme Court to change a restrictive precedent.
It's impossible.
The system is inherently biased toward those who can afford to purchase appellate shifts.
The game board isn't just tilted. The heavily capitalized players are actively allowed to rewrite the physics of the game while it is being played, simply because they can afford to keep rolling the dice until they get the rules they want.
And consider the compounding effect of that victory. Once General Electric successfully purchased that precedent, once the Supreme Court decreed that you can patent a microorganism who benefited the most.
Well, not the little guy.
No, it was not the lone biologist working in an independent lab. The ruling triggered an explosion in the biotechnology industry, but that industry was immediately dominated by heavily funded conglomerates. They utilized the Chakrabarty precedent to patent genetic sequences, modified seeds, and entire biological pathways.
More moats.
Yes, rapidly building massive, impenetrable statistical moats of biological intellectual property. The shift in the law exclusively benefited the entities capable of mass filing the newly allowed subject matter.
It is the ultimate expression of asymmetric warfare. And the leverage doesn't stop at what you are allowed to patent. Oh no, it extends to exactly where and how you can enforce those patents to maximize the financial bleeding of your competitors.
Procedure is a weapon.
Which brings us to a case that sounds like incredibly dry procedural lawyer stuff, but is actually one of the most terrifying lethal weapons in the corporate arsenal. Brunette Machine Works v. Cockham Industries.
Procedural mechanics are often more lethal than substantive law. This 1972 case deals with venue, which is the highly strategic decision of where a patent infringement lawsuit can be legally filed.
Okay, let's set the parameters of the dispute. Cockham Industries is suing Brunette Machine Works for patent infringement. The critical variable here is that Brunette is a Canadian corporation. Under United States law, they are classified as an alien corporation.
The Supreme Court, with Justice Thurgood Marshall writing the majority opinion, had to reconcile a conflict in venue statutes. Historically, the general patent venue statute, 28 U.S.C. section 1400B, was highly restrictive for domestic defendants.
Right.
It dictated that you could only sue a domestic company for patent infringement in the judicial district where they reside or where they have committed acts of infringement and maintain a regular, established place of business.
And the logic there is fair, right? It's designed to prevent a massive New York corporation from suing a tiny startup based in Seattle in a Miami courthouse just to make the travel and logistics impossible. It protects the domestic defendant from being dragged across the country to a hostile environment.
But the rules invert completely when the defendant is a foreign entity. The court ruled in Brunette that the restrictive protections of the patent venue statute simply do not apply to alien defendants. Instead, they fall under the broader alien venue statute, 28 U.S.C. section 1391D.
Okay, and what does that mean?
The ruling established that an alien corporation could be sued for patent infringement in absolutely any federal judicial district in the United States.
Any district at all.
Any district.
So if I am a startup based in Toronto or London or Bangalore, and I attempt to sell my innovative product in the U.S. market, a massive U.S. conglomerate can file a lawsuit against me literally anywhere they choose.
Anywhere. What is fascinating here is how this procedural ruling creates the framework for jurisdictional arbitrage. For a well-funded corporate plaintiff, the ability to sue a foreign entity in any district is not a matter of geographic convenience. It is a calculated tactical weapon designed to accelerate the financial exhaustion of the defendant.
It's weaponized geography.
Exactly. The conglomerate engages in aggressive forum shopping. Their legal team will analyze the data on every single federal district court in the country. They will not choose a court because it is close to their headquarters.
No, they'll choose a court that hates defendants.
They will choose a court based on algorithmic hostility. They look for districts with a historical statistical bias toward plaintiffs in patent cases. They look for courts with local rules that impose notoriously complex, protracted, and expensive e-discovery requirements.
They will drag you into a rocket docket district, right? Where the judge forces the trial to happen in 12 months instead of 3 years, meaning you have to spend your entire $4 million defense budget immediately, completely destroying your cash flow and forcing you into bankruptcy before a jury is even seated.
The objective of jurisdictional arbitrage is to maximize the friction and cost of engagement. If they can drag an undercapitalized foreign competitor into the most expensive, inconvenient jurisdiction possible, they alter the math of settlement.
Because it's cheaper to settle than to show up.
The foreign startup realizes that merely fighting the venue motion will cost hundreds of thousands of dollars. The simplified enforcement enabled by a brunette is a massive force multiplier for capital.
So if you are the global innovator listening to this right now, let's synthesize this absolute nightmare. You have a brilliant, world-changing idea. You look at the system and think, I should patent this to protect myself.
A critical error.
If you do, you walk straight into the disclosure trap. The patent office demands your blueprint, they reject you on a technicality like Benson, and your trade secret is permanently gifted to the public domain for conglomerates to exploit. If you decide to invent around existing technology, you slam into the statistical node.
The overlapping patents.
You face thousands of overlapping Diehr-style patents that staple software to conventional hardware, backed by corporations who used their wealth to literally redefine what can be owned, just like they did in Chakrabarti.
And if you somehow manage to navigate all of those domestic traps and you attempt to bring your hardware or software to the U.S. market from abroad, the conglomerates unleash jurisdictional arbitrage.
Right.
They leverage the brunette precedent to drag you into a courtroom 3,000 miles away from your headquarters in a jurisdiction explicitly chosen by their algorithms to maximize your legal expenses and drain your capital reserves.
They aren't trying to beat you on the merits of your technology. The technology is irrelevant. They are trying to bankrupt you before the trial even begins because they know you don't have the $4 million required to play the game, and they do.
It is a pure war of attrition, and the terrain is exclusively fortified by those who arrived first and possess the deepest pockets. The cold conclusion we must draw from synthesizing the mechanics of Benson, Diehr, Chakrabarti, and brunette is mathematically inescapable. Participating in the United States patent system without the requisite capital to defend your portfolio, which today means holding tens of millions of dollars in reserve, specifically allocated for prolonged litigation, is an act of financial suicide.
Pure suicide.
The system is structurally designed to extract value from the undercapitalized and consolidate it among the heavily capitalized.
If you are the small guy, the global innovator, the startup, without a massive legal war chest, you simply cannot play the stars game. You cannot afford to flood the zone with 2,000 patents. You cannot afford to purchase Supreme Court precedents.
Therefore, the only viable rational path is the SAND strategy, complete uncompromising secrecy. Discretion is not just the better part of valor in this landscape. It is the only viable survival tactic. You do not file applications. You do not publish your findings. You keep the blueprint hidden behind firewalls and locked doors. You treat your core innovation entirely as a trade secret. The moment you engage with the patent office, you are stepping onto a battlefield where the opponent controls the terrain, writes the rules of engagement, and dictates the venue of your execution.
It is an incredibly bleak reality, but it is the reality. We promised you a deep dive into the raw mechanics of leverage today, not a naive celebration of the inventor's myth. To summarize the trap, Gottschalk v. Benson illustrates the fatal disclosure trap, where a rejected application strips you of your trade secret and legally gifts it to your competitors.
Diamond v. Diehr demonstrates how conglomerates construct statistical moats, bypassing algorithm restrictions by stapling software to hardware to flood the zone with litigation landmines.
Right, and Diamond v. Chakrabarti proves how massive capital can push appellate litigation all the way to the Supreme Court to rewrite the very definition of what can be owned, literally patenting life itself.
And Brunette Machine Works weaponizes the map, allowing giants to drag underfunded foreign competitors into inescapable, mathematically ruinous jurisdictional arbitrage.
The $4 million toll booth is always waiting. Engaging the system ensures you will have to pay it.
It's unavoidable.
So, we leave you with a dark, final question to mull over as you build your company. If engaging with the U.S. patent system is functionally a trap, a highly engineered mechanism that legally extracts the trade secrets of the underfunded for the direct benefit of the wealthy, at what point does a startup founder applying for a patent cross the line from naive optimism into a literal breach of fiduciary duty to their own company?
That is the core question.
If you know the system will likely expose your IP, trigger a $4 million defense cost, and drain your capital runway, are you violating your duty to your shareholders by even filing the paperwork? Should true innovation just remain forever in the dark, hidden like sand, simply to survive?
It is the defining risk assessment calculation every innovator must run before they decide to make their work visible.
Because once the blueprint is visible, you can never get it back. The precision machinery is broken, and the muddy waters are full of predators. Thank you for joining us on this deep dive. Stay hidden, stay smart, and we will catch you next time.